In a recent video, I explained that you might not need a DUI lawyer if your case qualifies for a DUI diversion first-time offender program in the jurisdiction of which you were arrested. But I've got a case here that we need to talk about because it's one of the caveats. So this case seems like a simple DUI, but this guy definitely needed a lawyer in order to get into diversion in the first place, and he dang sure needed a lawyer when he got kicked out of diversion 8 months later. All that's up next. So here's the facts. We got a Hispanic male, 30-year-oldish, and married with 2 kids. He's making $80,000 a year. 2 days after he's arrested, he's fired from his job and has no source of income. This is the first offense, never been arrested for anything else in his life, just wants the case to go away so he can get back on his track. Once he got fired, he landed a job working a third shift at a factory for a little while, and he's currently working back in management, not quite to the salary he left before the DUI, but getting closer to it. DUIs put your life in a tailspin. There's no doubt about that. He's out, he's had a couple drinks, and he wakes up to the police officer knocking on his window. He's parked on the side of the road. He smells like alcohol. The cops are asking what he's doing there. Doesn't have any really good responses. It's just a bad situation to be in, and the situation gets worse when the cop asks for his driver's license and my guy presents a credit card. It is what it is. So those are the facts we're dealing with. Now, one of the concerns that I had from my client during the initial consultation was, will you get accepted into pretrial diversion? Now, pretrial diversion is simply a contract that you enter into with the state of Florida, and it kind of takes the judge out of the picture. The judge has to approve it, of course. It's not like you're hiding anything from the judge, but it's an agreement between the state of Florida, the state attorney's office, and the defendant, and they say, hey, if you jump through these hoops, then we'll give you this result. And these diversion programs are designed to lessen the harshness of a DUI offense while still achieving the goal of reducing DUI deaths and that sort of thing. First offender program. We're assuming you're not going to drink and drive again after you got popped once. After getting out of jail, the client made some phone calls, met with some different attorneys, and he sat down with me the day after his arrest. I'm not sure where I fell into the loop there, whether it's earlier or later on, but he ended up hiring me. Bottom line is, we anticipated that his case would go into pretrial diversion. First offense, didn't seem to be any egregious facts. But I warned him that this particular county, they consider passing out, being passed out, or sleeping at the wheel on the roadway as egregious driving. I mean, I get it why they say that, but I don't know if it's egregious. So I was concerned that this case may not qualify for entry into the diversion program based upon the fact the police report has him drive or parked on the roadway. But there's a little bit of ambiguity there. It's not really clear exactly where he was parked, some conflicting information. At the first court date, just as expected, the prosecutor wouldn't allow my client into the diversion program because she said he was passed out behind the wheel in the roadway. I asked her permission to reach out to the supervisor, didn't want to go behind her back, got that permission, and the supervisor agreed to keep an open mind, because we didn't have the video yet, to determine whether this client would be accepted into PTD based upon whether he was stopped in the roadway or in the grassy area. If he's in the grassy area, that's okay. It's almost like he pulled off to the side of the road and went to sleep. That was an intentional act. But if he's passed out in the roadway, that's driving at a level of intoxication where you just fall asleep in the middle of driving, and that's considered dangerous. You know, you could go the wrong way one way. Get it? So that was a critical factor. The supervisor was reasonable enough to allow that determination to take place. It took about 3 months to finally get him approved into the program, fighting back and forth. I don't know whether we actually got evidence of where the vehicle was actually parked or whether the supervisor just got sick of me hounding him. Either way, we got him in the program. So the case is done as far as I'm concerned. We got him in the diversion program. He's got to jump through a bunch of hoops. One of those hoops, because he had such a high BAC that he has to jump through, is the interlock device. So he has to get that interlock device installed into his vehicle and have it on there for 6 months. No fun. Nobody wants it, but if you want your case dismissed, it's not that bad or not that far out of the question. Had a high BAC. They want that. You just do it. But what you got to be aware of is you can't have any alcohol when you're driving, and even products that don't typically contain alcohol that you don't think of, like gum, mouthwash, and that type of stuff, often cause false violations, and those false violations can get people kicked out of diversion. And that's the phone call I got from him next. He got kicked out of the diversion program. We're going to talk about that in the next video. Appreciate it. Check it out. Have a good one.